Hi, everyone. Harry here to talk about the E Jean Carroll defamation trial that's coming up just next week and some pretrial rulings that the judge in that case has made to try to keep Trump from being Trump. Of a piece with the other YouTube tape you can find today talking about what happened at the AG fraud trial. There's another judge from New York here, a federal judge who's just on to Trump and is making rulings accordingly. Okay, to set the stage just a little bit, E. Jean Carroll, remember, reports or writes up this episode with Trump that happens in 1991 in Bergdorf Goodman's, so well beyond the statute of limitations, although a little asterisk there as it later came within because New York passed a special law for sexual assault victims to bring for 1 year an open window. And she did bring it, did E. Jean Carroll, and win it against Trump along with defamation. But this is the defamation that he did actually first when he was president. He came out on the lawn and said, she's made it all up and this never happened. And, you know, in his gallant way said, she's not my type. And, you know, was really like a total asshole, I think it might be the legal term here. And so she sued him for defamation then. Why is this one happening now where the other one already happened? Because he had been president then, so he claimed a measure of immunity. He basically said, it's my official act. And when that happens, the Department of Justice comes in and represents me. Oh, and by the way, that would have meant the dismissal of the case because the United States gets to choose the circumstances when it's subject to being sued, and intentional torts, which is a defamation, is not one of them. So that whole claim of whether he is doing his official action bounced around different courts, including the DC State Court. I won't bore you with the details or why it happened, but finally, just this week, the Second Circuit gave the final nail in the coffin, and he's not immune, so he has to face this claim, and it's the first one he did, but the second claim he faces. Okay, because it's the second claim, the judge, Lewis Kaplan, was able to say, you know, when parties have already litigated something, then it's considered established and you don't normally do it again. And that's the case here. So he said, look, we're not talking anymore about did he defame her. He defamed her. That's already been decided. This is just about how much he owes her for that one episode, and that much, whether it happened is off the table. So it's going to be a trial on damages. E. Jean Carroll's asked for $10 million plus punitive damages. And that's what the jury will decide. So in the last day, Judge Kaplan has issued a ruling talking about certain evidence that comes in and doesn't come in. And it really is strikingly a bit similar to what is going on in the fraud case, because they understand if given an inch, Trump will take a mile of trying to basically just make a campaign stump speech and say why he's being treated unfairly, or maybe disparage her again and the like. In the last trial, he did exactly that even as it was going on. Okay, so Judge Kaplan says, look, let me tell you some things you can't talk about. And that's because he's been talking about him, and her attorney, a very fine, especially for this setting, victims of Me Too or sexual assault, named Roberta or Robbie Kaplan, had moved and said, don't let him say any of these things. And the judge had agreed. By the way, Kaplan, Roberta Kaplan, and Lewis Kaplan, the judge, no relation. Needless to say, I hope. Okay, so he wants to say that E. Jean Carroll's been getting money from liberals, and that's how it's all funded, and it's all, George Soros or whatever. No, that's off the table. It's irrelevant. Trump wants to be able to say that Roberta Kaplan, her attorney, is a sort of crusader and a big Democrat and anti-Trump. No, that's off the table. Also off the table, as it should be and is now more and more in cases involving with angles of sexual assault. He wants to be able to talk about her past relationships, what, according to Kaplan, sexual disposition. I'm not even sure what that means, in prior sexual experiences. And Carroll wrote a column for many years having to do with matters of the heart, but also sex. And so, there's a lot he could try to make hay of, but no, that's been cut down. And then he just can't try to say he didn't sexually abuse her. He can't try to say that, he thinks she's lying. He just can't try to say that she's doing it for, in the words of Kaplan again, political agenda, financial interest, mental illness, or otherwise. He can't say anything, any argument inconsistent, I'm quoting now, with the court's collateral estoppel decision determining that Trump, with actual malice, that's lawyer talk for defamation, lied about assaulting her. That's defamation. And what's left after that's been proven is what are the damages. And that's what's up for grabs. And all those things that he can't do, I think. And, Robbie Kaplan said, please don't let him say this. They want to get it straight in advance. So when he tries to do it, if he tries to do it, it will be, objection, Your Honor. All right. But there's then one other thing that she can do. And Kaplan has ruled, he did this in the last case too, that the Access Hollywood video will be received in evidence. Now, you may remember this is actually the first time it was occurring to people, including me. Oh, well, that's it now. He can't survive this, Donald Trump, and how wrong and tragically wrong we were. But here's where he's on TV. He's talking, I think it's Billy Bush, who's a sort of cousin in the Bush family, and he's boasting what he calls locker room talk, but it's not locker room talk that I've heard, and it's really just very vulgar. He says, when you're famous, they'll let you do whatever you want. You can grab them by the pee, and you probably remember it was really notorious and ultra obnoxious. The jury is going to be able to hear that. And I just want to talk about that a little, because that, I'm not sure, is a good ruling. And I'm not sure it's in E Jean Carroll's interest. Robbie Kaplan, her lawyer, very good, very aggressive, and you want to focus on winning the trial, but you don't want to do something that will give an issue on appeal that you can then have the whole thing reversed. And so I just think it's worthwhile to underscore this. And it may be, in fact, that even though she's been given the right to do it, the Robbie Kaplan decides not to, because look, the episode happens in 1991. That is, the assault happens, the rape. There's a little, is it rape or is it not rape? But I think it's going to be, Kaplan has ruled it's rape, as that phrase is conventionally used. And 1991, 2019 is when he defames her. The Access Hollywood tape is from 2005. Now, Kaplan has said that it goes to his state of mind, potentially Trump's. You can see it. I mean, if you sort of, heard this about a stranger, you would say, okay, sounds like maybe he's a misogynistic jerk. Maybe he's more likely to be the kind of guy who would sexually assault someone, 15 years before. But you could also say, and there are laws, of evidence about this, that I'm not sure that really advances the ball very much, just to actually prove what he did in 1991. And it's kind of, it really makes him look like a total misogynist asshole. And that there's a doctrine in the law that says evidence that, first, if it's irrelevant, you can't admit it. But even if it's relevant, if it is going to have a real tendency to unduly prejudice, that's the term in the law. And unduly means, because it's not just that it makes him look bad, but it makes him look bad in a way that doesn't really go to what people are trying to prove. To me, if the jury hears this, it's an automatic issue on appeal. And it might be something where Kaplan wins the battle and loses the war. So it just really struck me as a litigator and someone who's tried a lot of cases and knows the rules of evidence, that it's an interesting ruling, one that maybe is more than Kaplan should have been pushing for, and maybe we can really take stock during the trial. Will she in fact play the Access Hollywood tape? And if we're around and remembered and not subject to terminal Trump exhaustion, when this ever goes up on appeal, we can see if this becomes an issue that the Court of Appeals actually says, you guys blew it here. The judge shouldn't have let that in. Now it's got to start all over again. Because to my mind, as sort of seeing it from afar, that's a definite risk here, and I'm not sure I would take that risk even if the court let me, which it's doing here. Okay, but basically all kinds of things, understandable things, since it's already been decided that he can't go into, and we're just going to basically have a case that she tries to prove damages, and he tries to say that they're small. They include, by the way, she's asked for $10 million in compensatory damages, but also punitive damages. And Trump has a real record of continuing to defame her, and there's real possibility that the jury very much socks it to him on punitive damages. So we'll see, but that'll be the possible big variable that could really, we talked just earlier today about potential $370 million in fraud. Now, let's put in another 30, 40, whatever. We're talking about in these civil cases a real price tag for a guy who is supposedly a lot less solvent than he makes out to be. Anyway, check out that trial. It'll only be for punitive damages, and see in particular if the Access Hollywood tape comes in. But that'll all be coming to a courtroom near you if you live in New York anyway, and soon. And it'll probably take a couple weeks. So that's part of the tsunami of litigation coming Trump's way, starting basically right now. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.